Summary judgment, it promotes judicial efficiency. Why? Because if the court can resolve an issue in a case, that means the jury doesn't have to. Winning summary judgment can force a defendant to come to the negotiating table. My name's David Scher. I'm a partner at Block, O'Toole & Murphy. When an attorney tells a client that they're going to make a motion for summary judgment or ask a court to grant summary judgment, what the lawyer is really saying is, there's an issue in the case that he or she believes can be resolved by the court without the need for a jury. All of the facts that are relevant on that particular issue point in one direction, and that is in the client's favor. As a simple example, let's say someone was involved in an auto accident where they were driving a car, they were stopped at a red light, and another vehicle suddenly hit their vehicle in the rear. The party representing the victims in that front car can make a summary judgment motion on the issue of liability. In other words, they would say to the court, "Judge, as it pertains to whose fault this accident was, there's really no fight here. There's no need for a jury. If you look at the facts and you look at the law, the court should be able to resolve the issue of liability on its own." And once the court does that, what the court is doing is granting, in this case the plaintiff, our client, summary judgment. Summary judgment is not only an effective tool for advocates, it's also an effective tool for the court system itself. It can dispose of certain issues quickly and efficiently. Any type of case can potentially qualify for summary judgment. Any civil case in New York, if a party or an attorney feels that there's an issue that should be resolvable by the court, a motion can be filed for summary judgment under CPLR 3212. In our field of personal injury law, the most common summary judgment relief that's sought is summary judgment on the issue of liability. In other words, on the issue of fault. The motion is asking the court to find, as a matter of law, that the accident was entirely the fault of the defendant. When I'm representing a client and deciding whether or not a summary judgment motion is appropriate, there's a few different factors that any good lawyer would consider. First of all, you have to consider the merits of the motion itself, the chances of success. You want to know that you're filing a motion that you can win. We always want to act in good faith with the court. And we would never want to file a motion that we believe is impossible to win. That would be frivolous, that would be a waste of the court's resources, and ultimately a waste of our client's time and our reputation. The other thing that must be weighed when you're filing a summary judgment motion for a client is that while that motion is pending, that can cause a delay in the case. So you have to balance the chances of success of the motion against the potential delays caused by the motion itself. If a summary judgment motion is, let's say, a close call, the party who loses the motion is very likely to file an appeal of that motion, which can again take some time. Everything must be considered by the attorney. But in the end, if we feel that we have a strong summary judgment motion to make on behalf of our client, we're going to file it because it's going to make the case stronger. If and when we file such a summary judgment motion, and if we win on our client's behalf, that does a couple very important things. Number one, it establishes fault 100% against the defendant. That issue is now resolved. It does not need to be tried before a jury. That eliminates risk of a jury coming to a different conclusion. So it represents finality of an issue in our client's favor. That's great. The number two thing winning summary judgment does when it comes to the issue of fault is it imposes interest on the defense as of the date liability is established. And that interest will continue to run from that date up until when the ultimate judgment is satisfied. So it shifts the incentives in a lawsuit. It makes the defendant incentivized to come to the table, cut his or her losses, and try to settle a case before more and more interest accrues. Every lawyer from time to time is going to file a summary judgment motion and lose, meaning the court will deny the motion. The court will find, I'm sorry, but there are material issues of fact here. We cannot summarily decide this issue as you want. It is going, in fact, to a jury. When we do lose a summary judgment motion, when it's denied by the court, our firm has another decision to make in that moment. And the important decision there is, do we accept the decision or do we appeal? Do we appeal the decision to a higher court? And that's an important tactical decision. Very often we will appeal the decision. Sometimes we won't. But what's the reason we would appeal? Well, if we feel that the judge got it wrong, the judge made some mistake of fact or some mistake of law that we believe can and would be corrected if we have a chance to argue to the appellate court. Why would we not choose to appeal? Well, there's a couple reasons. Number one, we may feel that the judge's decision, while we don't agree with it, was still fair and within the bounds of the judge's discretion. We may also feel that pursuing an appeal on that issue for the client would waste more time as opposed to proceeding forward with the case. Remember, if we file for summary judgment and the motion is denied, it doesn't mean that the case is over. It just means that the case is going to proceed to trial and that a jury is going to have to decide that issue. Now, oftentimes, we would rather proceed to trial, get the client justice faster, rather than hit the pause button on the case and go to the appellate division on the chance that we'll overturn the decision. So these are tactical decisions that are made very carefully by our in-house motion and appellate team here at Block, O'Toole and Murphy in consultation with the handling partner and attorney in the case. And of course, as always, in consultation with the client, who's the ultimate boss. And we'll always give the client our best advice, our best guidance on how to proceed. When injury victims are considering which law firm to hire, I think normally they're probably thinking about trial. Who's going to be the best trial lawyer to stand up for me? And they're right to think that. But there are other considerations too. Most of the work that goes into a case happens long before the trial. And most cases settle even before trial. So it's important to consider not only the trial skill of a firm, which this firm certainly has and has proven through its verdicts, but also how is that firm going to handle the case before trial, when it's likely going to be litigated and ultimately settled. One thing that's important is how does the firm handle motions and appeals? Because a successful summary judgment motion in your case can set your case up for success. It can set your case up to resolve faster and for a better number. At Block, O'Toole and Murphy, we have a dedicated team of attorneys who handle motions and appeals. Why is that important? Because that team every day is honing their skills in terms of research and writing, in terms of being up to date on the latest developments in case law. And that's going to benefit you as a client, because when we file papers, when we make a motion for summary judgment to the court on your behalf, you can bet that those papers are going to be solid, they're going to persuade the court, they're going to overwhelm the other side, and strong motion papers lead to strong motion results for you.